Morning to those of you who have jumped on already. We're just going to give it a minute or two here and give everyone an opportunity to sign on before we get started, but we will begin shortly. Thank you.
Liz, can you try just moving to the next slide to see what happens? Okay, and then go backwards. Perfect.
I'm going to go ahead and start my little spiel so we have plenty of time to answer any questions that our attendees may have. So thank you for joining us for today's webinar with Alan Singleton of Singleton Law Firm. Before I hand it over to Alan, just a few quick things. You are welcome to ask questions. We just ask that you submit those via the chat box and we will get them covered before we close out today's webinar. And you will also receive a follow-up email later this afternoon with a link to the recording. So if there's something that you missed or want to go back and revisit, you will have access to do that as well. Yes, Jacqueline, I see your message in the chat. We can see you and you are able to message us. So just a quick note, attendees, cameras and mics will stay off, but you are welcome to put any questions or comments in that chat box. So I will hand it over to Alan and we can go ahead and get started.
Well, thank you, Jordan. I appreciate the opportunity to visit with everybody today. This is sort of intended to be appropriate for the audience that I believe may be in attendance or may look at this at a later point. The intellectual property is not something you could typically touch. It's different than physical property, which is either your pen or pencil. You can hold that. You can touch real estate. That's a type of property, but that's real property and personal property. Intellectual property is a type of intangible property. You can't really see it, but there are certain rights around intellectual property. And the goal for businesses that are sort of oftentimes in the kind of Main Street business arena, small business getting started, maybe somebody who wants to open, an artist-oriented boutique or a coffee shop or a retail establishment. One goal is to avoid stubbing your toe. So maximize your business value by not hurting yourself. Don't do something that causes difficulty or causes losses to you. So first, do no harm is what the doctors always say when they practice medicine. And as you think about intellectual property, and we'll talk about what is intellectual property more here in a bit. Think about, well, first, I don't want to do something that's going to harm my business. And by not harming your business, you're going to help it. And then second, can you do something that adds value to your business? Can you, in the medical arena, can you start taking a medicine to lower your cholesterol? Or can you secure a trademark that gets you the right to sell your goods on Amazon, for example? Something of that nature. So can you add value? So make sure you don't take a medicine that hurts you. Don't do something intellectual property wise that hurts you. And then if there are opportunities to invest modestly in some intellectual property protection that might help you and add value to the business, then you can evaluate those things. There is a cost most of the time to a number of the intellectual property protection measures. So you always have to, as a business person, you have to weigh the cost compared to the likely return on investment. So if your business is, selling things on Amazon and they require a registered trademark, well, you may have to get the registration. If you're a mom and pop coffee shop with a name that is sort of common and appears in a number of different communities, but there's no likelihood of confusion in Champaign-Urbana right now, you may just start using the name and use TM on the name, for example, but not go to the measure of seeking significant costs and incurring significant costs to seek registration. So next slide. And I will say, please do chime in to the chat. I'm used to having a lot of uh, back and forth and not had seen faces, not being able to see reactions of people on this discussion is a little different. So please do chime in the chat if you have questions or perspectives. I have a question here. Will we get the slides from the presentation? I think that's one for Jordan. Jordan?
Yes, you will get the follow-up email with the link to the recording, and then if Alan's okay with it, we can put the PDF version of the PowerPoint into a Dropbox and share that as well.
Great. Sounds good. Yeah, and I'll share a copy of the slides with you. See, David Needham just responded. Thanks, David. Good to see your name and hope you're doing well. So here we go. So this is IP at a glance. The kind of this is a little bit different emphasis than sometimes what I give on this topic. If I were speaking at a university to people who are licensing IP from the U of I that relates to a new invention. But for a lot of Main Street businesses, trademark is a big issue. And trademark is your brand name, your logo, especially the name in particular. As you think about your business name, what you want to call your business, if there's another business in town and you have a lot of walk-in traffic or you have any walk-in traffic, you're a restaurant, that there's going to be a confusing name locally, then, best avoid that. If you have, if you're picking a name that is in conflict with a, a national brand, or you believe that there could be some pushback from a registered mark at some point in time, you want to avoid that. And so the logo and things of that nature are, I would say, secondary in importance compared to, do I have freedom to operate under my name and under my company name and what I call my products or services? But that's a big, very important issue. Copyright in a trademark is a way of identifying goods and services. If somebody sees that name, if they see Nike, for example, it's going to be a certain quality, a certain look. If you see McDonald's, that food is going to be of a certain quality and type and look and taste and etc. So copyright is an area that is sometimes pops up a lot, especially for small businesses who have websites. And so it's easy to download some images and populate them on your website. And you think that, well, I paid the fee and I have the right to use it, but you have to read the fine print. A lot of times it says that it's only available for use by a not-for-profit organization or something of that nature. And so you end up getting a cease and desist letter. Copyright can also come into play for artists who are developing original works of authorship. Copyright can come into play for photographers or people who are creating creative works for others. Who owns that copyright? Or if you hire things created for you and pay the freelancer, do you own the copyright? Does the freelancer own the copyright? Those are things you need to make clear. Patents are inventions. These are the most costly. So think about something that is new, useful, and non-obvious, and you might have to spend $20,000 or more to get from point A to all the way to an issued patent. So a big investment. Now, you can start the process for as little as, maybe $100 if you do everything yourself. But a patent is sort of a very powerful tool, but also a very expensive tool. And for a lot of Main Street businesses, that won't be the tool that you will be using. But there are individuals who build things that are truly patentable, and it makes sense to seek patent protection, especially if you have an ongoing business with revenue and this product has traction in the marketplace already, or if you have you believe it will have traction in the marketplace and you're going to have significant sales, then you have the cash flow to realize a return to pay the cost to get the patent and to hopefully realize a return on the investment. Patent gives you the right to exclude others from infringing on the patent. So that's an important concept to understand. It doesn't necessarily give you the right to practice the patent. So if somebody has a ballpoint ink pen and it has a patent on it, then you come up with a retractable version so that you don't get ink all over the place and you don't have to have a cap to put on the end of it. Assuming neither one of those had been invented, then you could get a patent on the retractable version. Somebody else held the patent on the ballpoint ink pen. You cannot manufacture ballpoint ink pens that are retractable unless you got a license or unless you got a or bought the ballpoint inserts from the other party that holds the patent. Trade secrets, that's just confidential information in general. Sometimes it can be very valuable. If you're a chemist and you have a particular way of doing things, your customer list can be confidential information. Recipes can sometimes be confidential information or trade secrets. I grew up in Robinson, Illinois, the home of the Heath candy bar. And the rumor is that, you know, the recipe for the toffee was obtained from a champagne business way back in time. And I went to school with the Heath kids. There was a big factory there, and that company really blossomed during World War II and ended up with a lot of products sold all over the world at that point in time. It's gone through a couple of merger and acquisition events. Famous trade secrets would include the formula for Coca-Cola, the KFC secret recipe. A lot of times for businesses, it's sort of the way you do things. You don't have to show everybody exactly the way you do it, everything, your customer list, confidential information about the business. And the way you protect trade secrets is you just have to keep them confidential. And you need to make sure that you take steps at your company to do that. Next slide. Okay, here we go. Trademark, trademark, copyright, patent, trade secret, contracts. Okay, so contracts are a lot of times the way. Hi, Jeannie. Okay, you were hearing from Jeannie Dow here. I think you might be from the Eastern Illinois, Charleston area or Mattoon area. I remember your name. So you've probably spoken on a topic like this a time or two, at least a lot on entrepreneurship. Glad you're here. And her question is, she's writing a workbook and a facilitator guide. I own an LLC consulting business, and I will probably be retiring in 5 years. Should the business or should I hold the copyright for the book? I may be able to sell the business, but like to retain the book. I would say probably you would want to own the copyright yourself, and then you could, especially if you are the only owner of the LLC, you could license it to the LLC or have an arrangement with the LLC to sell it. That way, if you do dissolve the LLC, the copyright's still in your name. In other situations, say if somebody had invested, $1 million in your LLC to help fund the research and development to write the book, that investor might require that or make it a condition of their investment that you assign the copyright to the LLC because there are other parties involved in the transaction there. But if this is your own one owner LLC, then I would suggest that you continue to own the copyright. Thanks for the question. She says it's her own. Great. We are talking a little bit of detail. If there's something horribly, confidential, I felt comfortable with those questions, but then we would take things offline. This isn't protected by the attorney-client privilege, so it's general in nature, but I think we're pretty good so far. So contracts are very important. So if you do have some confidential information or potential, if you want to enter into a potential agreement where you're going to be sharing confidential information, trade secrets, future product development designs, and it's at a high level, say for a tech business, or you're going to be sharing some software code to have some discussions, then use of a non-disclosure agreement is a good idea. If you have an employee doing work for you, you want to have an employment agreement that would provide that the employee would assign all intellectual property they create while under your employment to the company. So you want to make sure that the company itself becomes the owner of the intellectual property. The exception being if you're the only owner of the company, then it's more of a judgment call. Um, Another area of an IP agreement is, say you hire a photographer to take some pictures. Typically, the photographer would own the copyright to that. And so you might get all the pictures taken for a setting fee of $100, but then you don't own the copyright for $100. If you want to own the copyright, the photographer might be willing to do that, but they might also charge $1,500 for the sitting fee or to come out to your business and take all the photos, and then you would own the copyright or get a copyright release in that case. I'm using those numbers vaguely, but in general, in a situation like that, it might be a different fee depending on whether you own the copyright. Other settings are if you hire somebody to design a logo for your company on, Fiverr or one of those sites where you can hire things done, or just an independent individual around town or independent ad agency. Who's going to own that? Ideally, if you pay for it, you own it, but it's something to discuss and consider. Next slide. Why IP matters for small business. Protect your brand and creative work. If you are a creative type, it's nice to, if you have a whole portfolio of artwork, for example, assert copyright to it. Put the C symbol on it, your name, the year, at some location, so that you are asserting your common law copyright protection to it. Increase value and credibility, build trust with customers, avoid legal issues with unintentional infringement. That's the one issue that I see cause a lot of headaches for people, for small business. They just pick a name and go with it, and then all of a sudden they get a cease and desist and they have to rebrand. That's not a lot of fun. And then build business in your sale, build value in your business for later sales. So if you do build customer goodwill and people really come to you because of your brand, then having protected those trademark rights, for example, enhances your ability to achieve an exit when you sell. Next slide. Okay, this was the concept I kind of covered at the beginning. Freedom to operate versus a competitive advantage. Number one, if you do what you intend to do, are you going to get a cease and desist letter or a demand letter from an attorney saying you have to stop that, or even worse, a lawsuit? Even worse, the state's attorney calling upon you. I had one individual who was called me, who was selling knockoff Gucci handbags, sort of at a pop-up tent. He said, "Hey, well, I'm telling everybody they're knockoffs, and but the state's attorney is saying you can't do that." And I'm like, "Well, you can't do that. That's actually a crime." So make sure you have freedom to operate, freedom to do what you want to do, and aren't going to have to immediately rebrand. I would say it is always a risk management issue, in the sense that you have to do the searching that you can and make educated guesses sometimes. There are so many businesses out there, and with the internet, it's no longer just what's happening sort of in Champaign-Urbana that matters, because everything's on the web, and so we have everything all over the world sort of that could potentially be a conflict. The analogy I make is, try to make sure that your airbags are working in your automobile and you wear your seatbelt, and try to obey the traffic laws. And if you do that, there's no guarantee that you won't get hurt in a car accident, but that's sort of the standard of care. So try to meet that standard of care, so to speak. And then competitive advantage. Can you go out and protect some IP that will give you an advantage in selling your product or service in the marketplace, add value upon exit? Next slide. Here's some common IP mistakes. Using a name already in use. Letting others keep your intellectual property that was created for your business. For example, You don't have agreements with your with your employees. You pay an independent contractor to do some design work for you, and you neglect to get an assignment of the copyright. Um, if you have a 20 employee business, and assume that there's walk-in traffic, the person who handles the incoming calls and walk-in traffic shouldn't have access to the trade secrets. That individual has no need to have access to trade secret information. So limit trade secret information access to those who have a need to know. Misusing open source or stock content. We talked a little bit about stock content earlier. That's downloading the image. Open source software can also be an issue. If you do develop software and you utilize something called open source software that has copyleft provisions in it, it says that basically you're obligated to disclose to the public any software that you create that includes lines of code from that copyleft open source software. And so that may be okay if you're not worried about disclosing your source code. But if you want to protect your source code, because that's what's going to help make your business valuable, then you want to avoid utilization of open source code that has copyleft provisions in it. Next slide. A trademark is anything that identifies your brand to customers. It identifies a source of goods, basically. If you think about a trademark, you'll think, oh, okay, it came from that source of goods. And why does that matter? Well, it's like your reputation, sort of. And you don't want somebody diluting your reputation. Um, uh, when I first moved into town, Champaign County, they asked me, are you related to this person? I have no idea. Well, same last name. Did that person have an amazing reputation, not a good reputation? You know, it had the person had the same name, so there was potential for, confusion, I guess. In the product and service arena, there's also the potential for confusion. And if somebody buys something that looks like yours and they think it's from you and it's of poor quality, then that's going to be hurting your brand. And so that's the reason you want to protect your brand and your trademark rights to the extent you can. The name is the most important. Logos sometimes you can build value around slogans, even sounds or colors. The Intel chime, dun, 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 I think that was it. Slogans, be all you can be. Nike, just do it. Colors, I think juicy fruit yellow was a color at one point. Next slide. John Deere green. What makes a strong trademark? If it's made up, Zappo says the shoes. If it's arbitrary, an unrelated word. So Apple as to computers was arbitrary, and there was no likelihood of confusion with respect to Apple as to records. You have to be a little bit older to remember that reference, but then of course, music and computers sort of merged at some point, so there was confusion. So that had to be sorted out. But there was strong trademark rights around Apple, and Apple is a very strong brand at this point in time. But everybody can still use the word Apple to sell apples. So if it was a generic use of using the term Apple to sell apples, no trademark rights would surround that. Apple as to computers has strong trademark rights. Suggestive, you can get some trademark protection around that. Netflix, Flix, I guess, movie, and net on the internet. And even if it starts out a kind of weak, but gets a little bit stronger, now everybody thinks of Netflix. It's a famous mark. So if it starts out weak, it can get strong over time when it becomes famous. And then weak, tasty burgers. Well, that just says what it is. And so you don't really get very much protection at all over tasty burgers unless it becomes hugely famous. Next slide. Here's some examples. The name DuPont, the logo. you're in good hands. Allstate, the shape of the Coke bottle, Intel chimes. I don't know if you spend any time in an attic, but fiberglass insulation makes you itchy. But the pink for Owens Corning fiberglass insulation was a trademark color. Next slide. How to protect a trademark, choose a distinctive name. So not the tasty burger example. Search to see what's out there. USPTO, the state trademark search, Google, social media, domains. You can start using it on your product or service. You can file trademark application ahead of time as an intent to use basis. That's sort of a strategic question, but really trademark rights accrue through usage. If you stop using the trademark, you lose your rights. If you file an application before you start using it with the USPTO and you never start using it, you don't ever get an issued trademark. You can't squat on a trademark name. You can squat on a domain name, but you can't squat on a trademark really. So that's the reason the University of Illinois continues to sell a few items of chief merchandise each year. They want to maintain that as a trademark so that others can't sell chief merchandise, which they might do, indiscriminately. The university wants to control that. So they sell only a few items of chief merchandise each year, just enough to maintain the mark. Before you register, you can put the TM symbol on it. Then after registration at the federal level, you can put the R symbol on it. And it's important to mark the trademark appropriately. If you have a one-page handout which uses the mark multiple occasions, you should use the R symbol or TM symbol at least one time, or sometimes you put it down in the footer. The registration process can be expensive and can also start a fight that you don't want to start. So say you just decide, oh, I'm going to file, no harm, no foul. I'm just going to file a trademark application with the USPTO and see if it goes through. You start doing business under your name and you file the trademark application. Well, it turns out you're infringing on somebody who is big and monitors all the applications. Then you end up with a cease and desist letter that you, for two reasons. Number one, you're infringing on somebody else's mark. Number two, you sort of took a swing at the schoolyard big bully in the sense that you sought to claim some rights around that name. And so they felt the need to confront you and not only say withdraw your trademark application, but also stop doing business under that name. So it can start a fight you don't want to finish if you seek registration and you encounter an opposition from a large party. There's also state trademark registration. If you're only sort of a Main Street business, only doing business within the state of Illinois, then you can, it's an additional protection. It's a little bit vague. It's sort of like a bootstrap on the common law trademark rights. But it can add a little bit of value. You have to have 3 examples of proof of use in commerce. You send it into the Illinois Secretary of State, and they take a look at it. And sometimes they'll register things that won't get, that the U.S. Patent and Trademark Office won't. But they do require full proof of use in commerce, and you have to have 3 examples. So yeah, the cost is a lot less at the state of Illinois level. Next slide. Here we go. One thing that kind of gets overlooked a lot of times is a lot of people just will search if they're thinking about doing, starting a new business, they'll go to the Illinois Secretary of State and see, hey, is the name available? And they check the Illinois Secretary of State and, oh, nobody's got that name, but they don't think about the trademark searches at the state level or the federal level, or all the Google searches of what the conflict is. So, if you're doing business as a sole proprietorship and you haven't, formed a one owner LLC, really there's some value in protecting your name through actually filing articles of organization as a one owner LLC, because a lot of times that's quite honestly the first place people look. It doesn't achieve trademark rights, but it does keep somebody from using exactly your name. to do business, and it may cause them to kind of look at what you're doing if they see that conflict, to think about, hey, am I going to have a problem? Um, so that's something to think about, is actually forming an entity. There are other good reasons to form an entity, but just kind of letting the world know that you're using that name, at least in the state of Illinois, is I think sometimes an overlooked step and value to forming an entity such as a limited liability company or a corporation. The state trademark application gives some protection in Illinois for goods and services. Um, the really, the scope is Illinois, and if you're not doing business except for locally, then that can be the appropriate level. If you don't have resources right now, sometimes you do that to file a federal, or if there's good reason not to file a federal anyway, sometimes people pursue the state. The federal registration is the strongest, and it gives you the right to a number of legal rights and the ability to hopefully stop others from infringing on your mark. I will say that there are marks that are very strong and there are marks that are very weak. Sometimes I look at the USPTO search and I see about 8 registrations or 15 registrations that look very similar. So that's an area where the USPTO is choosing to allow a lot of people to register things that are pretty similar and pretty close to each other. Others, it might be with a famous mark, for example, or a very unique mark. Then the ability to get a trademark application through would be more limited. The trademark applications do vary upon class. So there are, trying to see, I've got my paper on the wall. I've got 34 classes of goods and then 10 classes of services. So at the federal level, you have to understand what class you are registering in based upon what you're doing. And so you have to pick your class and you have to come up with a description of what you're doing. And so it could be that the registration that you see for a particular service that's very unrelated to the goods that you are offering is not going to keep you from getting a registered trademark. Next slide. Here's an interesting concept. Sometimes people set up a company and they develop an entirely separate brand. Uh, Oftentimes it's nice to, if you are thinking about your brand and you haven't formed your company, to try to name your company that in a way that corresponds to your brand. Not that you can't develop other brands or product names that would be subject to trademark protection that would fall under your company. But if you're just getting started, that's a nice way to kind of give notice to people that you are kind of claiming that name. It doesn't secure trademark rights, but again, it's a way to kind of announce to the world a little bit and maybe avoid a conflict later on from a later party entering the arena. Next slide. Okay, business name versus brand versus product name. So the legal name of the business, it's the official name registered with the Illinois Secretary of State. You use it on legal documents, contracts, IRS tax filings, banking, etc. If you sign a contract, it would be Blue Sky, if that was your name, comma LLC by JD Dow, comma manager or sole member or have whatever representative capacity it's signed in. And sorry, Jeannie, to use your name, but that would be an example if that was the name of Jeannie's LLC. If you adopt an assumed name, you can do that. I do recommend that you do that with Illinois Secretary of State. There's a way to publish in the local paper, but that really is only for sole proprietorships and it doesn't give you any legal liability protection like a limited liability company does. So again, if you say you call your company something, but then you really want to rebrand the entire company, sometimes people adopt an assumed name. you can use that on your contracts, marketing, signage. But again, you need to register it with the Illinois Secretary of State. Your trademark, brand, or product name, that can be different than your legal business name. And you would use it, market on products. Uh, Mattel had the Barbie line and Ken and all that kind of stuff, or different goods that they sold. So Mattel was the company name that would have trademark rights, but then Barbie would have been a trademark protected name as well. So, next slide. Copyright protects original works of authorship, as long as they're reduced to a tangible medium of expression. So since this presentation is being recorded, presumably it would be subject to some sort of copyright. If I'm just speaking to somebody individually and no recording, let's assume no notes taken, then there wouldn't be any copyright surrounding the words. But it has to be fixed in a tangible medium of expression is the word. So that could be something that's in writing, such as a book. It can be software. It could be a recording. It could be a picture, things of that nature. Next slide. Next slide. The easiest way to protect copyright is the C with the year on it. So copyright 2025, Jane Smith. That asserts common law trademark or common law copyrights. And that's what makes sense most of the time. If you are going to have something that could be potentially infringed upon a lot, something easy to copy, for example, then registering the copyright gives you stronger enforcement rights and the rights to statutory damages. So you don't have to prove profits, but you get a certain number of dollars per infringement. So if it's possible for somebody to infringe on a high volume, then certainly registration is a good idea. I would expect that probably book publishers have internal people that register the copyright on their books, for example. Next slide. Good question. Who owns the copyright? Jeannie asked about AI, and I actually thought about including some of those slides in here. I did a presentation to IASGBA perhaps a year or so ago, a local group of training group, and we talked about artificial intelligence and how that affects ownership of intellectual property. So that can affect copyright, that can affect patent as well. And I will say that if you use artificial intelligence to create something, a creative work, or if you use artificial intelligence to come up with a new invention, there are risks that it is not going to be subject to copyright protection, or it will not be patentable. But the analogy that I draw is that it is like a tool. AI is a tool and cannot completely take over the creative process. And so if you just type into ChatGPT, create an image of a construction worker who is putting stripes on the pavement. That's probably not going to be subject to copyright because you didn't sufficiently create or didn't contribute sufficiently to the creative work. It was mainly created by artificial intelligence. But if there's tweaking and you add more to it, it's just a piece of something that is a larger work of authorship, then I would argue that it's still a creative work that has significant human contribution and would be subject to copyright. I will say it's a gray area, and it's a constantly evolving area. So if you do, I mean, artificial intelligence is such a broad term now. If you use, Grammarly on your, if you have the app Grammarly to help you with grammar checking, it'll also help you with suggested words to fill into the memo that you are writing yourself. That's artificial intelligence. It uses artificial intelligence to do that. I would argue that Grammarly suggesting a substitution of a word here and there is certainly not gonna kill your copyright. Um, you know, but if you give a 3-word command to ChatGPT and it comes up with something, yeah, that's probably not a creative work that a human made. So works for hire. You want to have an employment agreement that says that the employer owns it most of the time. Freelancers and contractors, they own it unless rights are assigned. So most of the time you want to get an assignment of the rights, use some contracts to confirm ownership. Next slide. What is a trade secret? Confidential information that gives you a business edge, recipes, pricing models, customer lists, things of that nature. Um, in a manufacturing setting, it could be. I think of merger and acquisition event that I worked on recently, and a lot of the trade secret information is where they source their materials, what they pay for, particular screw or bolt, and what they pay for, or what they're able to sell their products at. What's their margin? How much do they pay their employees? What systems they use to design things. All those are, sort of confidential information that in a company like that would be a good idea to have employees sign something that they will keep things confidential and then limit access to only those people who have a need to know the confidential information. If anybody gets into a healthcare setting, there's HIPAA and all sorts of things that even go beyond that, but that's really beyond this conversation today. Next slide. How to protect a trade secret. Use non-disclosure agreements, limit access, label confidential information not to be shared. Any sharing of trade secrets would have a separate trade secret. Sharing information would only be on a very limited basis. And so highly confidential information you wouldn't even disclose unless it was a very, very, very rare situation. And then, train employees, build it into your culture. And it's only protected as long as it's secret. So if somebody does violate your trade secrets and disclose it to the public, or if somebody reverses engineers it, then it's no longer a trade secret. So you see how to make, XYZ, Chipotle's XYZ bowl or whatever. If it was a trade secret, it's maybe not anymore if somebody's reverse engineered it. We have Coca-Cola, but that's a trade secret, but we also have Pepsi Cola, Sam's Cola, RC Cola, who knows what else. People have figured out how to do something at least similar. And that's not a violation of Coca-Cola's trade secret. Next slide. A patent is something that's, it protects inventions, tools, physical products. A lot of the inventions I work with, sort of outside of what's kind of spun out of the research park, a lot of farmers come up with stuff. They weld things together, bring it in and say, this does this, this and this, and they may not even have a drawing, but they built it. I'm like, okay, yeah. And then you have to, well, it looks like maybe we can get a patent on it. Can you actually make money on that after you do so? Or perhaps somebody who works in the ag area, and there are a number of ag tech companies that build not aftermarket, but not the John Deere stuff and not the First Brand stuff, but ancillary things that solve problems on farms. And they come up with things from time to time that we are able to protect. So always the question is, if you invest in a patent, are you able to achieve a return on investment? It has to be new, useful, and non-obvious. If you apply for a patent, you don't always get an issued patent. Even if you do get an issued patent, there's no guarantee that you would make money. So for a business owner, it has to be thought of it as a potentially significant expenditure of funds, and you want to think about whether that's the right investment for you. But you also want to think about, okay, am I doing something that directly infringes on somebody else's patent, and are they going to immediately send a cease and desist letter if I try to do this? I would say the patents are very vague in the sense that, in theory, a lot of things infringe, but it's sort of a question of, am I in the face of this individual, this other patent holder? Am I taking on John Deere directly, and in a way that's going to be noticed and complained about? Next slide. A starting point is sometimes a provisional patent application. A lot of people leave off the word application, but you can get started for as little as $100 if you do it yourself and you file it. I would say that you have to put a lot of work into it to get any meaningful protection. If you've been through the process before, oftentimes you can do some of the drafting, and it holds your place in line for 1 year. So it preserves your priority date. The utility patent application is the real application, so to speak. You have to file it in order for the USPTO to read it. Typically, that's more expensive. The costs involve not only sort of oftentimes some searching to figure out whether you have freedom to operate, whether you're likely to get a patent issued, but then also drafting the patent application. And then once it's filed as a regular utility application, you have to argue with the patent office oftentimes, and then there are maintenance fees to keep it in place. So there are a lot of costs associated with patents. It can be a valuable tool for the right industry and the right business, but it is a costly undertaking. Patent applications are typically published at 18 months, unless you file a non-publication request. So sometimes people choose to keep things as a trade secret. So that's oftentimes a better choice. Other times you won't be able to keep it as a trade secret because as soon as somebody buys your product, they'll be able to see how it's made. Next slide. Getting a patent does give you the right to practice an invention. We talked about the ballpoint ink pen. Somebody has a patent on the ballpoint ink pen, you come up with a retractable version so that the ballpoint goes back in the housing. The only way you can make and manufacture the retractable version is if you get a license from the other patent holder who owns the patent to the ballpoint, or you buy the ballpoint inserts from them, or if you sell the housing to the party who owns the ballpoint patent. So that's another way to monetize. Try to do some searching ahead of time. There's different ways to search: USPTO, the Google patents, just general Google searches. Think about who sells what is similar to yours and see if they have registered patents. And then sometimes you can do searches based upon that particular business as well. Next slide. We've already covered this. Next slide. Licensing. So you get some intellectual property and maybe you use it in your business, but and you're monetizing it, but you're not using it in a particular field of use. You're using it in the restaurant industry, in trucks, in the mobile trucks, but you want to license it to airlines. I don't know, some other field of use that is different than yours. You can license the rights to your patent to these other fields of use. Sometimes it's based upon geography. Sometimes it's based upon, hey, I've stopped using my intellectual property and I just want to license it. I will say that most of the time, if you come up with something and you think you're going to file a patent application and they're going to make a bunch of money on licensing, unless you're sort of the world leader in that topic, it's a lot of work to do that, and it's certainly not a guarantee. There's no guarantee you're going to make any money on that. A better choice or a better time to invest in a patent is if you have an ongoing business that's selling product and you want to keep your competitors from infringing. That way you've got money to pay for the patent application. You've got a reason to go get the patent to keep others from selling product that's going to be a knockoff on yours. Next slide. When to hire a professional, I would say, think about it when you're filing trademark applications at the USPTO, and certainly at a certain point in the patent prosecution process, it typically makes sense, not to say that you can't do it yourself, especially maybe the provisional a little bit, but and it's always a judgment call. Licensing or assigning IP rights. If you have a business that's up and going, you want to expand or sell your business, looking at all those things. If you get a cease and desist letter, oftentimes it's good to check with legal counsel and make sure that you do things that are going to get you out of trouble a little bit. Next slide. IP protection is not automatic when you do registration. If you decide to register a limited liability company with the state of Illinois and the name's available, you can get processed pretty quick, a day or two or something. Trademark protection, patent protection, copyright protection or registration at the federal level, all those take time. And so it's delays and follow-ups and some costs associated with registration, and outcomes are not guaranteed, but they can be very valuable. And so things to think about. I have a question. Are trademarks an annual application? Okay. Trademarks are, let's see, if you use common law trademark, the TM symbol, you just keep using it. If you register with USPTO between year 5 and 6, and then every 10 years thereafter, you have to file some documents showing that you have continued proof of use in commerce and pay some filing fees. And with the state of Illinois, it's either every 5 or every 10 years, you have to show that you're continuing to use the proof of use in commerce. Here we have a slide about why IP searches matter. Well, first of all, make sure you're not starting a business or doing something that's going to cause a big headache to you. And there are different ways, not so much anymore, but a few years ago, I oftentimes get a call from someone, hey, I've invented this XYZ thing. And while I'm on the phone, I say, like this one article on Amazon, and they say, because I'm doing the search, I say, oh yeah, do some basic searching yourself before you try to, start paying attorneys or some other party to do it. You can search the USPTO database. You can search other databases, Google searches, things of that nature. Try to get a general feel for what's out there from a trademark perspective and from a patent perspective, if you're trying to do that. Then if you have resources and you want to follow up on it further, if the results are confusing, then seek counsel of an attorney. A search is never 100%. You can't find everything. It's impossible, hard to prove a negative. So it's always a judgment call, even if you spend a lot of time searching and hire outside individuals to help. Next slide. Here's a checklist. Search using names or content. Use TM early on, so these are kind of the low-hanging fruit. Before you pick a business name, before you think you're going to start selling something under a particular brand or product name, do some searching to try to avoid a conflict. We talked about different ways to search. If you're getting started, use the TM symbol on your brand or marked names that you want to protect. That's asserting common law trademark right protection. Use the C symbol for copyright works. The C symbol, your name, and the year it was written or created. And then the patent pending if you have filed a provisional application or a regular utility application. Once a trademark is registered, use the R symbol. If the patent is issued, you mark your products with the patent number. And use contracts and NDAs, non-disclosure agreements. Connect your brand to your business. Make sure you've got it linked somehow, and decide if it makes sense to secure trademark protection on your brand. If you're selling, $10,000 a year worth of product and it's going to cost $2,500 to get a trademark registered, and you don't have any intent to expand because this is sort of a hobby business, probably not a good, thing to seek trademark protection at the cost of $2,500. Um, the question popped up, can you do an NDA on your own? Non-disclosure agreement, and I would guess that you can find some forms online. They may or may not be helpful. Um, you know, I think it kind of depends on your level of comfort with these topics and where you look and things of that nature. I would again kind of draw an analogy to the medical field a little bit. There's so much information available on the internet and other sources at this point in time that consumers or patients are much better educated when they go to see their doctor now. That having been said, sometimes people go off sort of on the wrong tangent and don't look at credible sources. If you're looking at the Journal of the American Medical Association, that's a little bit more credible source than TikTok, I would say. But not everybody can understand what's written in the Journal of the American Medical Association. So sort of depends on the person and what sources you're looking at as to whether it would be the right thing and how important an issue is it to your particular business. Is it a really important issue that is going to, and as yours a high-tech business, then probably you ought to have an attorney take a look at it. If it's not as high-tech and the dollars are lower, you may weigh the risk and find one that you're comfortable with on your own. Next slide. Here's some real world examples. Looks like we're getting close on time. Hershey Kiss, trademark for, okay, so if we're in person, everybody would have a Hershey's Kiss, so sorry about that. But a good way to remember intellectual property protection is anytime you see chocolate, think, am I doing something from an intellectual property law perspective that is hurting my business? Am I going to infringe on somebody else's business? Or is, am I missing out on an opportunity to protect my brand? Or did I forget to get an assignment when I spent $15,000 having somebody develop some software for me, which I really should have gotten an assignment to the copyright for that and a copy of the source code. So Hershey's Kisses uses patents on the trademarks, copyrights, and trade secrets and contracts. It uses all those tools to protect the Hershey's Kiss. So whenever you see chocolate, think about how you can use intellectual property to avoid headaches and maybe add some value to your business. Next slide. Okay, next slide. Hot topics. Oh, I think we're almost out of time. Hot topics selling on Etsy or Amazon. That's where I get a lot of trademark questions. The open source code issue we mentioned, stock images we mentioned. Next slide. I saw a question from Jacqueline there, and I'll answer in just a second. Final takeaway, IP can be your business's most valuable asset, but you can also have a business where intellectual property really isn't a big component of your business, as long as you don't do something to cause you to get a cease and desist letter or stub your toe. So Jacqueline asked about patent drawings and the formalities required. At the provisional patent level, they are a little bit less formal, and that's one of the reasons that the U.S. Patent and Trademark Office has created that, or the law has been created to allow provisional patent applications to be filed with less formal drawings. With the formal drawings, there's sort of that have to be submitted with the regular utility application, at least in order for it to be issued. The general rules are no color, They have to be line drawings typically. They have to have certain markings at the top. They have to have a numbering system. You can't have words on them typically, only one drawing per page. And then there are a lot of nuances in how you do them that are sort of one of the bigger headaches in my practice, quite honestly. It's you know, sometimes we send it out to a drawing expert, sometimes we do it in-house, sometimes we have the client has drawings that are you know, in AutoCAD that, and they have a design team that can help with creating those drawings. But I would say that's one of the headaches when you get to the level of a full utility application that has to be dealt with. But the provisional patent application rules are a little bit freer and you have more flexibility. So good question. I think we're at time, but if there are any other questions real quick. Okay, Jeannie, I received an email saying one of my stock photos. Ah, yeah. So this is a common thing, and yeah, I get it. It's a very common thing, and it could be valid, it could be not. Getty Images is a big player in that area, um, and so I always recommend that people take their own pictures, quite honestly, or use a local photographer and get an assignment. Even if you get an image from a library, um, you know, maybe the image in the library grants you the right to use it, but maybe the library didn't own it. It's like, you know, if you go to the Brooklyn Bridge in New York, this is an old saying, but and you pay the guy $100 to own it, well, you may not have become the owner of the Brooklyn Bridge because that guy didn't own the Brooklyn Bridge. So I kind of favor creating your own images. If you do get a cease and desist, a lot of times it can be negotiated, and a lot of times it just becomes an annoyance, and you negotiate them down, and you pay them a small amount, and it goes away, and then you next time around create your own images is what I found. So anyway. All right. Well, I think I'll turn it over to Jordan now. Thank you, everybody. Thank you, everybody who asked questions. I really appreciate it. That helps keep it a little bit more engaged. And my contact information is there. And if you have questions, you're welcome to reach out. So thank you, everybody, again for attending.
Awesome. Thank you so much, Alan, for all the information. And again, thank you to everyone who asked questions. We really appreciate everyone interacting throughout the session. We are up on time for today, so we will go ahead and close out the session. Thank you, Alan and Liz, for joining us this morning, and thank you to everyone who participated. We hope to see you at another one of our sessions. Bye-bye, everyone.